I am a lawyer.
Do you understand that?
I am a lawyer. I don't need a lecture from you who doesn't understand the rules of evidence. Under the rules of evidence, the only thing that can come in under the rules of evidence is truthfulness and untruthfulness. So to the extent that you're trying to disparage me because you have me on videotape and embarrass me for things that you can't bring in, I'm going to raise, move to strike, find it objectionable, and then move for sanctions for harassment under Rule 30D. You can look it up if you don't know it.
Yeah, he takes it way too far. Big overreach here. Again, remember, the deponent can be asked any question in a deposition because its purpose is discover admissible relevant evidence for trial. Again, there's an exception there, you know, privileged material doesn't come in, for example, but he has to answer it, right? So it's not harassment. The deponent is totally in the wrong here.
Mr. Abrams, I feel quite confident that if any sanctions are entered in this matter, it's going to be against you.
Objective form.
For continuing to obstruct and not answer any of my questions.
Objective
You
form.
cannot object.
I just did.
You cannot.
I just did. I'm a lawyer. I'm a licensed, unblemished member of the bar. Unblemished.
Okay, so here you have ad hominem attacks by the deponent against the plaintiff's attorney. Totally ridiculous, poor and unprofessional conduct. Look, the deposition is for professionals. You ask the question, and if they want to be mean to you, if they want to be crazy, you just be cool. The crazier they get, the cooler you should get if you're asking questions. Plaintiff's lawyer is getting into it with the deponent. Don't do that. Just move on. Go to the next question.
If you laugh at me one more time, I'm going to walk out.
We're going to move for 30D3
We're
sanctions.
going to move for harassment sanctions against you right now. Okay, you're laughing at us with the videotape that you published on the internet about you and your rock band, and you're going to be laughing at me. And you've moved for sanctions that had him denied every single time in this matter, and the jury should see that too. Every single one has led to no sanction.
Mr. Abrams, are
Including
you
the last
aware?
one where we quashed all of your subpoenas. And you asked for attorney's fees and you got no sanction.
Mr. Abrams.
Let's move on. Do you have a question for me? You sued my firm belligerently under the abuse of your law license where we countersued you. We have a counterclaim against you for abuse of process for misusing your law license. You sued me for fraud, civil conspiracy, not civil conspiracy, conspiracy, which is a criminal act, so you did that wrong, and aiding and abetting, which is a criminal act, so you did that wrong. Ask me questions about that or I'm leaving.
The deponent's totally in the wrong here, trying to lecture the plaintiff's attorney asking questions. But while I would have done it differently, the plaintiff's attorney probably should start getting into the substantive aspects of the deposition. Look, a lot of times if you blow the deposition, you can't have a second. Normally you can have unlimited numbers or lots of, it depends on the jurisdiction, but lots of different depositions. You could depose different witnesses, different parties, but a lot of times, unless something new comes up, you get one bite at the apple. So he should probably start moving on to the substantive elements of his case in his lawsuit, because he wants to try to prove it. Instead, he's getting bogged down by this witness. Just keep moving. Be nimble.
Mr. Abrams, we're going to be here for a long time today if you do not answer my questions. I just want to...
So here he is again, editorializing, making it very dramatic. Just get on to the questions. This witness is totally combative, non-cooperative. So get to the point. Try to get to the meat of your case.
Let you know that right now.
Objective form.
And put that on the record. Mr. Sullenberger, I'm sorry.
Stop laughing at my lawyer.
This is bizarre.
Stop laughing at my
Bizarre.
lawyer and stop harassing us.
Listen, let's
You brought us down here for fraud. Ask us fraud questions.
Mr. Abrams, how many times has your firm been added as a defendant in any lawsuit?
As I can recall, one in the BB matter.
So the BB matter and then this matter as well? Those are the only two times you recall that your firm has been added as a defendant?
Yes, as I recall.
Aside from traffic tickets, have you ever been named in a criminal action?
Objective form.
Objective form and privilege, so I assert privilege and need not answer.
What privilege are you asserting, sir?
Attorney-client privilege, and we would, under the law, I need not answer that.
What law are you referring to, Mr. Abrams?
There's no way this is privileged because he's asking, are you a defendant in a criminal matter? You ever been a defendant in a criminal matter? That happens outside of the context of attorney-client communication, right? So how could it ever be privileged? Very bizarre.
I need a law book. And I move to strike, and I move for, I move to strike the question. I refuse to answer under privilege, and I move for a protective order on the question. So certify the question and move on.
You've again not answered my questions. You've
Objective
made a absolutely baseless assertion of privilege. Are you aware that in a deposition, the proper objections that your lawyer are allowed to make are as to form and as to foundation? If there is a matter that is privileged and your lawyer objects to it on the basis of privilege, he can instruct you not to answer. Otherwise, you need to answer all of the questions that I give
Objective
to you
form.
today. Do you understand that, Mr. Abrams?
He's raising an objection to privilege.
There's a pending question. Could you please read it back?
Okay, listen to the question.
What law are you referring to, Mr. Abrams? We can go back. Aside from traffic tickets, have you ever been named in a criminal action?
So the question is, aside from traffic tickets, have you ever been named in a criminal action, for example, as a defendant? Of course, there's no way that's privileged or attorney-client or other privilege, because those are things that happen outside of the attorney-client communication. Either you were a defendant and charged or not. Now, that might be reasonably calculated to lead to admissible evidence because in a lot of jurisdictions, evidence of a felony or a crime of moral turpitude would be admissible to impeach the witness. However, of course, that probably doesn't exist here because he's an attorney, probably a good standing member of the bar up until this point, or up until a little bit later. So yeah, that's definitely a question that is fair game. The deponent has to answer it.
So objection, privilege, move on.
You are not answering the question today. You're
Total bad faith objection. There's no way that's privileged.
Objective
to
form,
answer it, Mr.
objective
Abrams.
privilege,
Move on.
move on.
It's the answer. Objection, privilege, move on.
What privilege are you asserting today, Mr. Sullenberg?
Attorney-client privilege, he's already answered the question.
So Mr. Abrams is saying he has an attorney-client privilege over himself being named as a criminal defendant.
Yes.
And the question's intended to harass and annoy. And under 30D3, again, we're going to move for sanctions for repeated conduct like this.
I can't even get through my initial questions here
That's
because
your-
you are being
we-
so
How would that be attorney-client privilege? Is it like it's privilege because you represent yourself and you're talking to yourself? So bizarre.
obstructionist.
That's
today.
because you're a weak lawyer, but go ahead.
Wow. Okay. Ad hominem attack. Total not fair game. And that's probably sanctionable. And that's the type of behavior that attorneys should not be demonstrating in a discovery deposition.
You sued me for fraud. Ask me fraud questions. You sued my firm for fraud, aiding and abetting, and conspiracy. You have no evidence. Put something in front of me and we'll answer the questions. You have nothing. You have nothing.
Mr.
Put
Abrams,
something in
are
front
you
of me.
aware that Judge Starrs already ruled that there is substantial evidence against your firm that you committed fraud?
Object to
for misrepresentation of the
Are you
evidence,
aware?
mischaracterization. The fact that the judge let you bring your bogus claim against us doesn't mean that it's merit full. Do you have a fraud question for me?
Please answer the question.
He just did. Ask
I
me.
did.
Are you
We're
aware?
Yes, I'm aware. Move on.
Mr. Abrams, have you ever been arrested?
Object to form and privilege, attorney-client.
That's it. And you're instructing your client not to answer that question on the basis of attorney-client privilege, Mr. Sullenberger.
It's my understanding that Mr. Abrams had an attorney for any issues that may have arisen, and therefore he can assert.
I also don't recall being arrested.
What part of my question asked for any attorney-client privilege?
He's not being
communications?
deposed.
I don't have to. I objected. I objected to form. I objected for privilege for Mr. Abrams.
I am going to end this deposition now.
Okay.
Mr. Abrams, we're going to continue it while we seek intervention of the special master.
Fine.
It's clear that you are not here to answer any questions
clear that
today,
you're harassing
and
us.
you are refusing to answer
We've
any
answered
questions
every
today.
question, read every question down.
You have not.
We disagree.
Okay, let's ask.
Okay, what in the world is this guy popping? He's taking these pills left and right. What could they be? Who knows? It's very strange, though, but that would be fair game to ask because it could affect a deponent's ability to give truthful, clear answers. That's actually one question you ask in a deposition during the introductory phase. You know, have you taken any alcohol or other substances that might affect your ability to give truthful, complete answers in this deposition? Whatever he's taken, totally fair game to ask. Now remember, they can object under whatever grounds they want to object to and then bring it up later.
A couple more questions. Mr. Abrams, what are the pills that you just took?
Object to
There you go.
None
form.
of your business. None of
Privilege.
none of
What
your
are those?
business.
What are those other pills?
Object to form.
None of your
Object
business.
to privilege.
None of your business.
Medical privilege. Don't
Mr. Abrams, are you under any?
I don't know about medical privilege. That's very strange because remember, the privilege is the communication back and forth. Priest, parishioner, therapist, patient, doctor, patient, attorney, client. And also, you know, when it comes to privilege, attorney privilege, that might apply to materials prepared, work product, for example. But I don't know what medical privilege is because it's clearly something that's occurring outside of that communication and that confidential setting.
Any drugs today? Have you taken any drugs before you came to this deposition today?
No.
Okay. Have you taken any alcohol before you came to this deposition today?
No.
Any medication whatsoever?
No.
No. Just these pills that you're taking here?
Yes.
That you are refusing to answer what they are?
Yes,
Medical
none of your
privilege.
business.
Okay.
But I can tell you that if you took some of these, they would help get some of your weight off. I can tell you that.
Oh, you're referring to when you called me fat when you walked in here?
Object to
I don't recall
form.
that.
You don't recall that? Okay. Well, we have a couple witnesses to that, including Mr. Sullenberger. In any event,
If you want to raise your weight problem, Mr. Ward, with the jury and with the special master, please do. But we're not the ones that are sitting here in that condition.
Mr. Abrams, do you recall the motion to quash the subpoena for your testimony
Yes.
that you filed? And you attempted to quash the subpoena to disallow your deposition to be taken, correct?
Object to form.
I don't recall that. I remember we successfully quashed your bad faith deposition.
See, the plaintiff's attorney, I don't understand. He keeps talking about different circumstances unrelated to the cause of action. If I'm in a lawsuit, I am bearing down on the witness as it relates to their recollection, their personal knowledge of the event or events that form the basis of my lawsuit. This plaintiff's attorney, he's bouncing around a lot. He does get some leeway as far as introductory questions. He could definitely ask the question about the pills, but he's bouncing around a lot. Even so, the person deposed has to answer, right?
Positions, you moved for attorney's fees and you were denied by the special master. That's my recollection, that he found them, that he found them when we told you I would be out of town to, in bad faith, then scheduled the deposition to pull me out of my vacation. He found that to be objectionable, and he commended me on taking a vacation under the stresses of this profession. So I remember the special master commending me and quashing you. That's my recollection.
Are you here today pursuant to the subpoena?
Yes.
Okay. So your subpoena didn't get quashed, did it?
Yes, it did.
Sure didn't.
Yes, it did. Argumentative. Move on. What are you laughing at? Why do you keep laughing? What is it with you? Why don't you look at the camera and laugh at them?
Mr. Abrams, your testimony is being taken
Just
today.
ask me some questions about fraud, civil conspiracy, and what other trumped-up things you did under your license that we're moving for sanctions against you. Do you realize we sued you for abuse of your law license? Do you realize that? And that we're going to continue to sue you for the way that you've been treating in this matter? You have no evidence. If you do, show the jury, put it in front of us, and we'll ask questions. You haven't put one document in front of us. Open something up and make this a meaningful deposition, or let me go.
Is there anything else you'd like to say, Mr. Abrams?
Depends on what your next question is.
In the motion that you filed to quash the subpoena, isn't it true that you admitted to the special master that you were in fact in town?
Object to form.
We told the special master in a pleading that I returned at home at 3:30 in the morning on the same day that you scheduled my deposition, and that there was no way I was going to be able to come to the deposition with no sleep. We found
So you were in town at the time, you were in town on the time that you were...
So one of the things you never want to do is speak over each other. One of the reasons for that is the court reporter needs to take down everything and be very orderly about it. So if you're talking over each other, you can't see what's objectionable, who says what. It's very difficult, especially if you want to use that deposition testimony ever in the trial or some other hearing.
scheduled to be deposed, but you
Object to
nevertheless moved to
form.
Asked and
quash.
answered. Move on.
Mr. Abrams, are you refusing to answer?
I answered
Object
the
to
question.
form.
Move on.
You don't get to not answer when you object.
Object to form.
Do you
I
understand?
answered the
Plaintiff's attorney's totally right. Again, he has to answer.
question, and I even told you what time I returned on the day. What more? Why are you harassing me?
Mr. Abrams,
Stop harassing
listen
me.
to my questions. Today, that your job is to listen to my questions and answer your questions under oath. Do you understand?
Judge
Object to
asked,
form.
asked and answered. Move on.
I'm waiting for your answer, Mr. Abrams.
Her first question was the same question you asked. If we need to go back to the very beginning to ask whether I said I would be here under oath, we can go back and ask the court reporter.
Mr. Abrams, in that motion, you included that Mr. Abrams' anxiety requires him to take medication on extended flights that impairs Mr. Abrams' facilities. Can you please explain what medication you were referring to in your filing?
Object to form
No.
medical privilege.
Privilege.
Medical privilege.
Yes. Move
Yes,
on.
you have what privilege is that?
None of your
Absolutely
business.
no right.
No, what medicine I take is none of your business. Move on.
You filed a motion with the special master saying that because of a certain medication that
Yep.
you could not sit for your deposition.
Yes, that medicine's none of your business. Move on.
And now
Objection
you've
privilege.
come into this deposition today with a handful of pills
Yep.
that you refuse to answer questions about
Yes,
what they are.
None of your business. HIPAA protection privilege. Move.
HIPAA protection does not apply. Remember, I've said it 20 million times at this point, he has to answer the question unless it's one of recognized privilege. And medical privilege doesn't apply in this circumstance because it's not the communication between patient and doctor or treater. So something very important to keep in mind is if the medical condition is at issue in the case, for example, motor vehicle collision, all the treatment records, what you say to your doctor, if it's at issue, yeah, all that stuff comes in. I don't think it's going to come in later, but it's pretty clear that the guy being deposed, Mr. Abrams, is actually trying to make certain that it doesn't get out, probably. The correct vehicle for that is called a protective order. So what he would do after the deposition is move for a protective order over his deposition testimony, for example, that it not be published on YouTube, for example. But this is not the right vehicle to do it.
We are going to continue this deposition now, Mr. Abrams. You have made it clear you are not willing to answer any of the questions today. You have been objecting. We are going to move for sanctions against you and your firm for your conduct during this deposition, and we will take that up with the special master.
And we'll represent your conduct during this deposition.
Please do.
For the record, since the moment we've walked in here, I and my counsel have answered every single question and rightfully asserted 30D, I think it's
30D3.
for harassment. We've answered every single question. We've asserted privilege where counsel refused to accept privilege. And we've been nothing but harassed under 30D3. We're moving for sanctions. We're moving to quash the deposition for future. And we're here to answer all of the questions regarding why my law firm was surreptitiously brought into this lawsuit for fraud, conspiracy, and aiding. And he hasn't asked one question in furtherance thereof.
We will
Until he
continue
does,
all three of the
we will
depositions
move
that are
to
scheduled
strike.
for today, because it is very clear that Mr. Abrams, Mr. Sullenberger, and their firm intend to obstruct discovery in this matter and do not intend to answer the questions today. We will ask that it be reconvened before the special master.
One of the really interesting things about litigation is you can bring a sanctions motion on a sanctions motion. So it gets really wild. I mean, a lot of times judges don't want to deal with this unless it's really, really, really bad. And you'll find out soon enough that in this particular case, it was bad enough to merit sanctions and a little bit more.
With Abrams and Associates to pay the full amounts of everything associated with the depositions, including the special master's fee, and we will be filing a motion to take that up with the special master today.
We disagree. We're filing the exact same motion and seeking the exact same sanctions. Anything else?
We will continue the deposition and go off the record at this time.
We're going off the record at 9:38.
That was a truly wild deposition with a combative witness. However, there are some things to keep in mind, some lessons from this deposition. One is you need to control your witness, and you control your witness early on. Two, you need to set expectations of that witness, and you need to do that early on. The fellow deposing the attorney went off the rails. I mean, his deposition didn't seem to take much form or substance toward a result to uncover evidence of the fraud or whatever it was. Now, he was being obstructed, and the witness was overly combative. And what actually happened was it was sanctionable. The opponent got into a lot of trouble in this and actually got suspended, his law license suspended, based on this conduct and other conduct related to this matter. Another thing to keep in mind is work toward a goal. Plaintiff's attorney just kept going back and forth. He started fighting with the witness. Never fight with the witness. Another thing to keep in mind, stay on the rails. Remember the goal. In any discovery deposition, you want to uncover or discover evidence that makes your case better, makes your case stronger. And because the plaintiff's lawyer kept fighting back and forth with the deponent, he never really got to the substantive elements of the case. Now, maybe if he fought hard enough and was cool enough, maybe he would have gotten there. But he started fighting verbally with the deponent, and his goal of uncovering information, he failed at. Plaintiff's lawyer did the right thing by trying to engage the special master early. Unfortunately, the special master was not available. So, all in all, what a wild case. Thanks for tuning in to my channel. Be certain to like and subscribe. We're going to do some more reacting videos. Thank you for joining me in my very first YouTube video on this channel. See you soon.